Are you a caregiver for a loved one, finding yourself navigating a maze of unfamiliar terms like power of attorney or living will? It's a role filled with love and dedication, but it often comes with a steep learning curve, especially when it involves legal and financial matters. You might feel overwhelmed, unsure of where to even begin. This uncertainty is completely normal. The good news is that with the right knowledge and a clear plan, you can transform this anxiety into confidence. You can become the empowered advocate your loved one needs, ensuring their wishes are honored and their future is secure, all while protecting your own well-being in the process. The challenge for many caregivers is that legal and financial planning often feels like a crisis management task rather than a proactive measure. A sudden health scare or a change in cognitive ability can thrust families into a whirlwind of urgent decisions without a roadmap. Important documents might be missing, bank accounts inaccessible, and healthcare preferences unknown. This reactive state creates immense stress, potential family conflicts, and the risk of making costly mistakes. Without a plan, you might be forced to make difficult choices in the dark, guessing what your loved one would have wanted, which is a heavy burden for any caregiver to carry on their shoulders. This is where our guiding principle comes into play. Proactive planning is the greatest act of love and respect you can offer your loved one and your entire family. It is not about anticipating the worst. It is about ensuring the best possible care and quality of life according to their specific wishes. By addressing these topics early, when everyone is calm and capable, you replace ambiguity with clarity. You create a shared understanding and a legal framework that protects everyone involved. This principle shifts the focus from fear of the unknown to empowerment through preparation, ensuring that your loved one's voice is heard long after they may be unable to express themselves. Our action plan begins with the foundational legal documents. The very first step is to discuss and establish a durable power of attorney for finances. This legal instrument allows your loved one, the principal, to appoint a trusted person, the agent, to manage their financial affairs if they become incapacitated. This is not about taking control. It is about ensuring bills get paid, investments are managed, and financial stability is maintained without interruption. Without this document, your family might have to go through a lengthy and expensive court process called conservatorship just to handle basic financial tasks, adding incredible strain during an already difficult time. Equally critical is the healthcare power of attorney, sometimes known as a healthcare proxy or medical power of attorney. This document is distinct from the financial power of attorney and is absolutely essential. It empowers a designated agent to make medical decisions on behalf of your loved one if they cannot communicate for themselves. This includes choices about treatments, surgeries, doctors, and end-of-life care. The person chosen should be someone who clearly understands your loved one's values and is strong enough to advocate for their wishes, even in emotionally charged situations with medical professionals or other family members. It ensures their health is in trusted hands. Next in our legal toolkit is the living will. While a healthcare proxy names a person, a living will outlines specific wishes regarding medical treatment, particularly end-of-life care. It answers difficult questions ahead of time. For example, does your loved one want to be kept on life support? Do they want artificial nutrition or hydration if they are in a permanent vegetative state? Having these preferences documented in a living will remove the gut-wrenching burden of these decisions from the family. It provides clear instructions to the healthcare agent and medical team, ensuring that the care provided aligns perfectly with the individual's deeply held personal values. Another important document is the HIPAA release form. The Health Insurance Portability and Accountability Act protects patient privacy, which is a good thing. However, it can also prevent doctors from speaking with caregivers about a loved one's condition. A signed HIPAA release form grants specific individuals, like you, permission to receive protected health information. This is vital for effective caregiving. It allows you to coordinate with different doctors, understand diagnoses and treatment plans, and handle medical billing issues. It's a simple but powerful tool that ensures you have the information you need to be an effective advocate for their health and well-being. Once these core documents are in place, the conversation must turn to estate planning, which primarily involves a will or a trust. A last will and testament is a legal document that outlines how a person's assets should be distributed after their death. It also names an executor to manage the process and can designate guardians for minor children. Every adult should have a will, regardless of the size of their estate. Without one, the state's intestacy laws will determine how property is divided, which may not align with your loved one's wishes at all, potentially causing disputes and confusion among surviving family members. Now let's talk about trusts, which can offer more control and flexibility than a will. A revocable living trust is a common tool used in estate planning. With a trust, assets are transferred into it during a person's lifetime, and a trustee is named to manage them. The person who creates the trust, or the grantor, can be the trustee while they are alive and well. Upon incapacitation or death, a successor trustee they have chosen steps in to manage the assets according to the trust's instructions. This process completely avoids probate court, saving significant time, money, and preserving the family's privacy during a sensitive period. Understanding the difference between a will and a trust is key to making the right choice. The main benefit of a trust is avoiding probate, a public court process that can be long and costly. Assets in a trust can be distributed to beneficiaries almost immediately. A will, on the other hand, must go through probate. However, a trust is generally more expensive to set up and requires the active step of retitling assets into the trust's name. For some, a will is sufficient. For others, especially those with significant assets or real estate in multiple states like a home in New York and a condo in Florida, a trust is a far better option. Regardless of whether a will or trust is used, creating a comprehensive list of all assets is a non-negotiable step. This financial inventory should include everything: bank accounts, retirement accounts like 401(k)s and IRAs, investment portfolios, life insurance policies, real estate deeds, vehicle titles, and even safe deposit box locations and keys. It should also list all liabilities, such as mortgages, car loans, and credit card debt. Having this master document organized and accessible is an incredible gift to the executor or trustee, simplifying their duties and preventing assets from being lost or overlooked during the estate settlement process. Now we shift to the financial planning required for long-term care, which is a major concern for most American seniors. The costs of in-home care, assisted living, or a nursing home can be astronomical, quickly depleting a lifetime of savings. It's a reality we must plan for. The first step is to have an honest assessment of the potential costs in your area and the financial resources available to meet them. This is not a conversation to put off. Understanding the potential financial impact is crucial for making informed decisions about care options and how to pay for them without creating a crisis for the entire family. One option for funding long-term care is long-term care insurance. These policies are designed specifically to cover the costs of services like personal care assistance or nursing home stays. The ideal time to purchase this insurance is in your 50s or early 60s, as premiums are lower and underwriting is less strict. If your loved one already has a policy, it is vital to understand its terms. What is the daily benefit amount? What is the elimination period, which is the time you must pay out of pocket before benefits kick in? What specific types of care does it cover? Knowing these details is essential for activating and maximizing the policy benefits when needed. It is also critical to understand what government programs like Medicare and Medicaid cover, and more importantly, what they do not. Medicare, the federal health insurance program for those over 65, does not typically cover long-term custodial care. It may cover short-term skilled nursing care after a qualifying hospital stay, but it is not a solution for ongoing assistance with daily living. This is one of the most common and costly misconceptions among American families. Relying on Medicare for long-term care can lead to a sudden and severe financial shock when families discover they must cover the costs themselves. Medicaid, on the other hand, is a joint federal and state program that does cover long-term care, but it is needs-based. This means an individual must have very limited income and assets to qualify. For many middle-class families, this requires spending down their assets to meet the eligibility thresholds, which can be a complex and emotionally difficult process. Medicaid planning with an elder law attorney can help protect some assets for a healthy spouse, while still allowing the person needing care to qualify. This planning must be done well in advance, as there are look-back periods where asset transfers can be penalized. For those who have served in the armed forces, it is essential to explore benefits available through the Department of Veterans Affairs. The VA offers various programs that can help with the costs of long-term care, including the aid and attendance benefit. This is a pension benefit that can help cover the costs of in-home care or assisted living for eligible veterans and their surviving spouses. The application process can be complicated, so it is often beneficial to work with a VA-accredited claims agent or attorney to navigate the paperwork and requirements successfully, ensuring access to these well-deserved benefits. Beyond insurance and government programs, families should explore all other available financial resources. This could include tapping into the equity of a home through a reverse mortgage, although this option should be approached with extreme caution and professional advice. It could also involve annuities with long-term care riders or life insurance policies that allow for accelerated death benefits. The key is to create a mosaic of funding sources, piecing together different options to build a sustainable plan. A qualified financial advisor who specializes in elder care planning can be an invaluable partner in this process, helping you analyze and structure these complex financial tools. Now let's address one of the most delicate parts of this entire process: initiating the conversation. Bringing up topics like incapacity and death can be uncomfortable for both adult children and their aging parents. The key is to approach it with love, empathy, and respect. Frame the discussion not as being about decline, but as being about empowerment and honoring their wishes. You could start by sharing your own planning journey, saying something like, "I was just updating my own will, and it made me realize I have no idea what your wishes are. I would love to understand them so I can make sure they are respected." Choosing the right time and place for this conversation is crucial for its success. Don't bring it up during a holiday dinner or in the middle of a stressful event. Find a quiet, relaxed moment when no one feels rushed or pressured. It might be best to have a series of smaller conversations rather than one big, overwhelming meeting. The goal is to create a safe space for open dialogue. Reassure your loved one that this is about ensuring their voice is heard and that you are there to support them, not to take over. Patience and a gentle approach will pave the way for a productive and meaningful discussion. It is also important to involve all relevant family members, especially siblings, in these planning conversations. Financial and healthcare decisions can unfortunately become a source of conflict among adult children if they are not handled transparently. Holding a family meeting, perhaps with the guidance of a neutral third party like an elder care mediator or a family therapist, can ensure everyone is on the same page. This prevents misunderstandings and resentment down the road. It helps to clarify roles and responsibilities, ensuring that the burden of caregiving does not fall unfairly on one person's shoulders and that decisions are made collectively. When you do have these conversations, be an active listener. Your primary role is to understand your loved one's values, fears, and desires. Ask open-ended questions like, "What does a good quality of life look like to you?" Or, "What are your biggest concerns about the future?" Avoid making assumptions. Their priorities might surprise you. For some, staying in their own home is the most important thing, while for others, it might be ensuring they do not become a financial burden on their children. Truly hearing and documenting these wishes is the foundation upon which all the legal and financial structures will be built. As you gather this information, it is essential to organize it in a way that is easily accessible when needed. Create a caregiver binder or a secure digital folder. This should contain copies of all the legal documents we have discussed: powers of attorney, living will, and the will or trust. It should also include that financial inventory with account numbers, insurance policy details, and contact information for their lawyer, accountant, and doctors. A list of all medications, dosages, and allergies is also critical. This centralized resource will be an absolute lifesaver in an emergency, saving you precious time and reducing stress. Throughout this journey, remember that you do not have to be an expert in everything. The most important action you can take is to assemble a team of qualified professionals. An elder law attorney is indispensable for drafting legally sound documents that are specific to your state's laws and your family's situation. They can provide guidance on complex issues like Medicaid planning and asset protection. Do not be tempted to use generic online forms for these critical documents. The nuances of state law require professional expertise to ensure they are valid and effective when you need them most. A financial advisor who specializes in geriatric financial planning can also be a key member of your team. They can help you and your loved one assess the affordability of different care options, structure investments to generate income for care expenses, and analyze the pros and cons of products like long-term care insurance or annuities. Their expertise extends beyond simple investment management to the intricate financial landscape of aging in America. They can help create a sustainable financial strategy that provides for your loved one's needs while preserving assets for the future, offering immense peace of mind. Another professional to consider is a geriatric care manager. These are often social workers or nurses who specialize in navigating the complexities of elder care. They can be particularly helpful if you live far away from your loved one or are feeling overwhelmed by the logistics of care. A geriatric care manager can assess your loved one's needs, create a detailed care plan, coordinate medical services, and connect you with trusted local resources like home health agencies or assisted living communities in places like Phoenix, Arizona, or Tampa, Florida. They act as your local advocate and coordinator, easing the logistical burden of caregiving. Let's not forget the importance of tax planning in this process. A certified public accountant or CPA should be part of your professional team. There can be significant tax implications related to how you pay for care. For example, medical expenses, including in-home care and nursing home costs, can sometimes be tax deductible. There might also be tax consequences related to selling assets to pay for care or transferring property. A CPA can help you navigate these rules to maximize deductions and avoid costly tax mistakes, ensuring that you are managing the financial side of caregiving as efficiently as possible for your family. Once the plans are in place, they must be reviewed regularly. Legal and financial planning is not a set-it-and-forget-it activity. Life circumstances change. Your loved one's health may evolve, family situations can shift, and laws related to taxes and benefits are updated. It is a good practice to review all documents and the overall financial plan at least once every 3 to 5 years, or whenever there is a major life event, such as a new diagnosis, the death of a spouse, or a significant change in assets. This ensures the plan remains relevant and continues to reflect your loved one's current wishes and needs. It is also vital to keep the designated agents and successor trustees informed. Make sure the people named in the documents know where the originals are kept and understand the roles they have been asked to play. Give your healthcare agent a copy of the healthcare directive and living will. Talk with your financial power of attorney about the location of the financial inventory and their responsibilities. This open communication prevents a frantic search for documents during a crisis and ensures a smooth transition of responsibilities if and when they are needed. It empowers them to act confidently on your loved one's behalf. This process also involves planning for the caregiver's own well-being. Caregiving can be physically, emotionally, and financially draining. It is essential to build a support network for yourself. This could include joining a local or online caregiver support group, seeking counseling to manage stress, and arranging for respite care to give yourself regular breaks. You cannot pour from an empty cup. Protecting your own health is not selfish. It is a necessary component of being a sustainable and effective caregiver for the person you love. Your well-being is an integral part of the overall care plan for your loved one. Let's explore the positive outcome that this comprehensive planning creates. Imagine a scenario where your mother has a sudden stroke and is unable to communicate. Because you planned ahead, the situation is still difficult, but it is not chaotic. You have the healthcare power of attorney, so you can speak confidently with her doctors, armed with the knowledge of her wishes from her living will. You have the financial power of attorney, so you can access her accounts to pay for her care without missing a beat. The family is united, not divided, because everyone was part of the conversation and understands the plan. This proactive approach transforms a potential crisis into a manageable process. The peace of mind that comes from this preparedness is immeasurable. It allows you to focus your energy not on legal battles or financial worries, but on what truly matters, providing love, comfort, and support to your loved one. You can be fully present with them, knowing that the difficult decisions have already been made. This is the true gift of planning. It creates a calm and stable environment that benefits not only the person receiving care, but every single member of the family, fostering harmony and shared purpose. Furthermore, a well-executed plan protects your loved one's legacy and financial security. By using tools like trusts and strategic Medicaid planning, you can help preserve their hard-earned assets, ensuring they can pass on a legacy to their children and grandchildren if that is their wish. It prevents their life savings from being completely consumed by the high cost of care. This financial foresight provides dignity and honors their lifetime of work and saving. It ensures that their financial story concludes with security and generosity, not with depletion and distress, which is a powerful final act of stewardship. By taking these steps, you are not just managing a set of tasks, you are becoming a powerful, informed advocate. You are stepping into the role of a protector, a planner, and a leader for your family. This journey will build your confidence and resilience. You will move from a state of anxious uncertainty to one of empowered capability. This transformation is profound. It strengthens family bonds and equips you with the skills and knowledge to navigate the challenges of aging with grace and competence, ensuring the best possible quality of life for your loved one every step of the way. And what about the impact on your own life? As a caregiver, your financial health is also at stake. Many caregivers reduce work hours or leave the workforce altogether, impacting their own retirement savings and social security benefits. By having a clear financial plan for your loved one's care, you protect your own financial future. You avoid having to drain your personal savings or go into debt to cover their expenses. This comprehensive planning is a dual act of protection, securing both your loved one's future and your own, ensuring your dedication does not lead to your own financial hardship later in life. Let's talk about the emotional benefits for your loved one. For many seniors, a deep-seated fear is becoming a burden on their children. By involving them in the planning process, you give them a sense of control and agency over their own life. It reassures them that their wishes will be honored and that a plan is in place to manage their needs. This can alleviate a great deal of their anxiety about the future. Knowing that they have organized their affairs provides a profound sense of peace and closure, allowing them to focus on living their remaining years with joy and purpose, unburdened by financial and legal worries. Consider the alternative for a moment. A family in Texas without a plan faces a medical emergency. The father is incapacitated, but his adult children cannot access his bank account to pay for the specialized care he needs. They disagree on the course of medical treatment, leading to bitter arguments in the hospital hallway. They have to hire expensive lawyers to petition the court for guardianship, a process that drains both money and emotional energy from the family. This is the chaotic and heartbreaking reality that so many families face. It is a reality that is almost entirely preventable through the steps we have outlined today. In contrast, a family in Oregon who has done their planning faces the same medical emergency with a different outcome. The daughter, designated as the healthcare and financial agent, steps in seamlessly. She presents the legal documents to the hospital and the bank. She coordinates with her siblings, who are already aware of their father's wishes because they had a family meeting months earlier. While they are sad about their father's condition, there is no chaos or conflict. They can focus on supporting him and each other. This is the power of proactive legal and financial planning in action. This process also strengthens intergenerational relationships. When done with care and empathy, these planning conversations can be deeply meaningful. They offer a chance for adult children to better understand their parents' values and for parents to see the love and responsibility in their children. It can be a time of profound connection, where unspoken fears are brought into the light and addressed with collective strength. It is an opportunity to work together as a team, reinforcing the bonds of family and ensuring that you are all moving forward with a shared vision and mutual support, which is invaluable. So as we bring our discussion to a close, remember that legal and financial planning is not a one-time event, but an ongoing conversation rooted in love. It is a journey you embark upon with your loved one to create a future defined by clarity, dignity, and peace of mind. The path may seem complex, but by breaking it down into manageable steps, securing core legal documents, understanding the financial landscape, and fostering open communication, you can navigate it successfully. You have the ability to build a comprehensive support system for your loved one and for yourself. Our empowering takeaway is this: you, the caregiver, are the cornerstone of your loved one's well-being, and proactive planning is your most powerful tool. Do not wait for a crisis to force your hand. Start these conversations now, assemble your team of professionals, and create a clear, actionable plan. By doing so, you are giving one of the most meaningful gifts possible: the gift of security, the gift of honored wishes, and the gift of a peaceful future for the person you love. This is your path to becoming a truly empowered and effective caregiver, ready for whatever lies ahead.